Hearing the appeal of Jersey Choice Limited against His Majesty's Treasury.
Mr. O'Neill.
My lords, my lady, I hope that you can hear me clearly enough.
Well, we can hear you, but you're a little bit faint.
Does that help with the microphone closer? I could speak louder.
I think we need to adjust the volume at this end on the speakers. You're not going to be able to keep your voice up for the whole of your submissions.
Well, I could try. I do have lots of water, but it might be difficult.
Yes. Can we do anything about the volume? Thank you. Bear with us for a moment, Mr. O'Neill. We'll just see if something can be done to improve that.
Obliged.
We'll try again, please. Mr. O'Neill, I think your microphone might have been boosted now.
Okay. Is that clearer, my lord?
It was for a moment.
It was for a moment.
Oh dear. I can speak as loudly as possible straight into the microphone, if that helps.
That's okay.
Yes. We'll try that for now, Mr. O'Neill, and we'll hope that during the course of your submissions that we'll be assisted by someone who can adjust the volume at this end.
I'm obliged to the court. I'm also very much obliged to the court for arranging for this to be a hybrid hearing, given my own personal circumstance.
Not at all, Mr. O'Neill. We're sorry that it is necessary, but it's the obvious thing to do in the circumstances.
But I am very much obliged, and I do realise the limitations of hybrid hearings. And as I say, I've attempted to try and anticipate and remedy shortcomings such as difficulties in hearing, perhaps, by preparing in advance and circulating both to the court and to the other side my proposed script for what I'll say, simply in order to allow, as it were, the idea of where it is that I'm going.
Well, Mr. O'Neill, so far as that's concerned, the rules do not make any provision for speaking notes, and the court does not find speaking notes helpful, so we will not be referring to that this morning.
That's fine, my lord. As I say, I'd simply put it up for such benefit as it might have, but it is what I'll be speaking to, so it is my personal script, but of course it's the oral submissions which count, and I'm perfectly aware of that, my lords. So then, to begin with, as I say, this is a appeal against the decision of the courts below by JCL to strike out on HMT's application the claim for Frankovich damages. Because we're the appellant before the court, and clearly that JCL has to present its case first, but the appeal still concerns the strikeout application made by HMT, and therefore it remains the case that HMT have to satisfy this court that it's right and fair and a proper exercise of the court's powers at this preliminary stage before any evidence has been heard for the court to strike out, basically on the basis that JCL has not pleaded a reasonable cause of action, the claim it's made for Frankovich damages. So this is all about the sufficiency of the particulars, assuming that even if the facts alleged are true, is HMT, Majesty Treasury, able to satisfy this court that, as a matter of law, JCL has simply failed out to make any case in the pleadings for its claim. If the court is not satisfied that Her Majesty's Treasury have made out that, then the case and claim must be permitted to proceed to trial on the evidence, and then the issue will be as to whether the pleading is supported by the evidence. So, these submissions then, which I make this morning, are necessarily predicated on my anticipating the case which HMT will make against me, and therefore seeking to answer and counter in advance the arguments which that Her Majesty's Treasury will make in seeking to convince the court.
I don't really understand that, Mr. O'Neill. You've lost at first instance and in the Court of Appeal, so you've got to persuade us that they were wrong.
Indeed, but the issue is, the question ultimately is, has a case been made out that we have no reasonable cause of action on our case as pleaded? It is a matter which comes before the court on these pleadings. There isn't a presumption that because we lost in the case below, therefore the pleadings have changed. We will certainly address the arguments which found favour with the courts below, but there is no presumption that because one has lost an appeal, therefore one has to get over a further hurdle before this court, because that would apply to every appeal before. Of course, we have to persuade this court round, but the basic proposition is that HMT say that we haven't got a reasonable case on the pleadings. That's what I have to address. That's what I have to anticipate. And all I'm saying is that if the court doubts and does not consider, even in the light of the judgments of the courts below, that in fact it cannot be said on the pleadings that there is no reasonable case to be made out, then the appeal should be allowed. So, in that regard, I, first of all, formally adopt the case which has been made and lodged, filed with the court for JCL, and that's at tab 4, pages 73 to 127 of the bundle. Now, the case goes on at some length, and I do apologise for that, because it is, at some length, a simple and straightforward point, which frankly, I've been finding it difficult to understand why anyone should find it so difficult, apparently, to accept and uphold. And that simple point is that EU law did not permit the UK to act in this case as it did by taking away low-value consignment relief from and only from all and any low-value goods which originated in the Channel Islands. We say that unless and until the UK receives specific authorisation from the EU legislature allowing it to derogate from its obligations under EU law, then EU law required the UK either to maintain low-value consignment relief for all low-value goods from outside the EU VAT area, which had their origin elsewhere within the territory which comprises the EU customs union or internal market, or it could remove low-value consignment relief for all low-value goods from outside the EU VAT area which had their origin elsewhere within the territory comprising the customs union. What EU law did not permit the UK to do was what in fact it did do, that is, disapply the low-value consignment relief selectively. They removed it from and only from all and any low-value goods imported into the UK which had their origin in the Channel Islands. But it kept
do you have a claim, can I ask you, do you have a claim that your client suffered loss because low-value relief was not removed from other places?
Yes, because we say that imported distortions of competition into the internal market and allowed for other territories such to take the competitive advantage from the fact that they had the low-value consignment relief maintained in this in their case.
So the claim for damages you want to make is it that is for losses calculated as sales that you lost out on because they were made instead by people selling seeds from the Ireland Islands or wherever they are.
No, that's not the claim for damages is anything, but, and that's the third issue, which isn't before this court, that which directly and is causally linked to the breach of EU law, which has been established in terms of the first condition. So the causality and the direct basis upon the loss will be a matter for the court below if this court accepts that a reasonable case has been made out in the pleadings for there being a breach of EU law in the first place. That's the only issue which this court is concerned with, not the issue as to how much the damages might reasonably be. That's a matter for trial.
Of course, but I just want to be clear that the loss you're claiming is the loss of sales that have been made by other territories from which the relief was not removed. Is that right?
No, the loss which we are claiming is the loss which flows from the failure to treat JCL in accordance with the principle of equal treatment.
Yes, you've just explained that would have been achieved by removing the relief from the other territories as well.
Well, there is a basic provision, it's a basic principle of EU law that if there is a breach of the principle of equal treatment, the appropriate remedy is to have placed the disadvantaged party who has been treated contrary to the principle of equal treatment in the same position as those who were not so discriminated against, which is to say that the remedy is based on the presumption of the Channel Islands are to be treated as the Åland Islands, the Canary Islands and the like, and therefore LVCR should not have been applied to them. So it's the losses which follow from the fact that LVCR was applied to them when it should not have been, and the losses which resulted from that. So that's the basis upon the damages.
Mr. O'Neill, can you help me in relation to this, please? Setting to one side for a moment the particular position of the Channel Islands,
yes.
Does EU law impose an obligation on member states not to discriminate in matters of tax as between imports from different non-member states?
As between different non-member states, the issue is this, and in a sense it's precisely that issue which has, in a sense, confused the courts below. But that is, there is no general principle of equal treatment which can be pleaded or relied upon by non-member states. That, as I say, is a matter which is a matter of agreement. And we've stated that at paragraph 2.10 of our case. But what that means is that the principle of equal treatment, the EU law principle of equal treatment, cannot be prayed in aid in relation to EU external relations law. For example, when the EU is concluding an external trade deal with non-member states, such as, for example, recent one, Singapore, or Canada, or indeed now, post-Brexit, the UK, those non-member states who are outside the EU cannot say they have any rights under EU law, or that the EU is somehow obliged to treat them in the same way and give them the same deal as they have given other non-member states.
So your case then rests on the position of the Channel Islands being different?
Absolutely so, and that's the clear blue water between us. That's that we say, of course, the Channel Islands are different because they're in the EU. The fact that aspects of EU law are disapplied from them doesn't put them outside the EU, and that's a fundamental error which HMT are relying upon. And it's a basic, fundamental category error in EU law, and I will go on and explain that. So yes, Channel Islands are not in the same position as non-member states. This case is not concerned with the external relations law or the common commercial policy of the EU. This is concerned about the free movement of goods and the customs union. And those are all internal, purely internal EU law matters. And it's because of that that the Channel Islands, unlike Singapore or Canada, can claim the principle of equal treatment, because the principle of equal treatment is the absolute basis, foundational basis for the very idea of the free movement of goods and the non-distortion of competition within the internal market.
I suppose a fundamental question then is whether this is concerned with the free movement of goods or whether it's concerned with a distinct matter of taxation.
Well, that's again, if I may say, my lord, points to the fundamental category error which HMT have fallen into again, because there's a tendency to go for what might be thought of as thinking of EU law in terms of silos. This is free movement of goods law, that's one thing. This is taxation law, and according to HMT, this is VAT law. Now, it might be very comfortable for lawyers to say, I'm a VAT lawyer, or I don't know, or I'm a free movement of goods lawyer, or at least I know about the trans-border shipment of waste in terms of their own specialisations, but that's not how EU law works. EU law works on the basis of general principles, which are then given specific expression in particular situations. So therefore, the general principle is of seeking to ensure the creation of an internal market without internal borders in which free movement of goods is ensured and there is no distortion of competition. That's the end point. And the way of getting to that end point is by way of seeking to ensure equal treatment of goods within the internal market and producers within the internal market. Now, that equal treatment principle is then given specific expression within the treaties in Article 30 in relation to not having charges, even of a fiscal nature. So it applies to taxes, which have the equivalent effect, not what they say, not how they're classified, but what in effect, what is the effect that they have to being equivalent effect to that of a customs duty. That's Article 30, equal treatment. Article 110 is also a statement of the principle of equal treatment, because that says that in matters of internal taxation, and they go on and define what would count as internal taxation, it's not enough simply to be classified as that, because we know that Article 30 also applies to internal taxation. As the principle of equal treatment applies there, there should be no discrimination between the taxation of goods, regardless of their origin. That's a statement of equal treatment. And the fact is that this tax does tax under specific reference to origin elsewhere within the customs union. And that makes it unlawful. And similarly, VAT law is not some kind of silo. VAT law is law which is secondary EU law, which has been made under and in terms of its legislative base, Article 113 of the Treaty on the Functioning of the European Union.
Well, you say it's secondary law, but
yes,
the treaty provides that the treaty shall apply to the Channel Islands to the extent necessary to ensure the implementation of arrangements.
Yes.
And Protocol 3 makes clear that community rules on customs matters are to apply. Is it not a matter of primary treaty law that VAT law, for want of a better expression, does not apply to Channel Islands?
No, it's not, and I'm going to come on to that, but just let me finish the point on how one understands VAT, and the siloisation is the wrong approach. VAT, the legislative basis for VAT, which is secondary law, it's not primary laws, VAT is secondary EU law. It's made under, in terms of Article 113 of the Treaty on the Functioning of the European Union, which is at page 630 of the bundle, and that says, the Council shall, acting unanimously, in accordance with special legislative procedure, after consulting European Parliament and the Economic and Social Committee, adopt provisions for the harmonisation of legislation concerning turnover taxes. So that's the legislative basis for VAT. excise duties and other forms of indirect, to the extent that, this is the important point, to the extent that such harmonisation is necessary to ensure the establishment and the functioning of the internal market and to avoid distortion of competition. So that law under Article 113 is also a free movement of goods provision, because it is created insofar as necessary to ensure the establishment and functioning of the internal market. The internal market of which the Channel Islands is a member. The distortion of competition which the Channel Islands can also play in aid. So we cannot say, oh, this is just bad law, nothing to do with us. All that the exclusion of the Channel Islands, among other territories, from the EU VAT area by secondary EU law means is that the Channel Islands don't have to internally apply VAT to the supply of goods and services within the Channel Islands. But what it does not do, and what HMP say it does, is to somehow take the Channel Islands outside and become equivalent to a non-member state when VAT issues are concerned, because VAT is not one discrete compartment. VAT is a turnover tax which has been created by secondary law, which seeks to ensure the establishment and functioning of the internal market and avoid distortion of competition, which is precisely what Article 110 does, and what Article 30 also does. So they cannot be separated and compartmentalised. What happens ultimately, of course, a decision is made as to which article or treaty article a particular charge on imports is to be classified under. But that's not a decision which is made a priori in the way that HMT say. They say, oh, look, it's obvious this is VAT because it looks like VAT, and we call it VAT, and it's very VAT-y. That's not how it works. It's you reach the conclusion after working out with the acutely fact-sensitive analysis as to how this charge actually applies in practice. And if it applies actually in practice, even if it's called VAT, even if it's called taxation, in practice it is effectively charged because and simply because of crossing a frontier, and is charged because and under reference to origin elsewhere within the internal market, then it's equivalent, it's a fiscal charge, or it's charge of a fiscal nature, which is equivalent in effect to a customs duty and therefore prohibited under Article 30. So that's the case which is made against HMT, which is made on the pleadings. And the response from HMT is simply not permitted or allowed for under EU law. This, because it's based on a compartmentalisation, which might be, as I say, congenial to English lawyers, but it's not how the treaty is set up or how EU law works. So returning to what I was, my script. So what I was saying is that EU law doesn't permit what was in fact done, the disapplication of LVCR selectively. And the reason for this is that when deciding to apply this charge to and only to all and any products which had their origin in the Channel Islands, what effectively happened in economic terms is that the UK exported into the rest of the customs area, the internal market area, the internal competition distortion which had allegedly been experienced on the UK domestic market as a result of the practice of round tripping. It exports that distortion of competition because it's selectively disapplied it. Now said, oh, Channel Islands goods, no matter all and any Channel Islands goods, low-value Channel Islands goods, shall now be taxed, but low-value goods from the Åland Islands and the Canary Islands will not be taxed. So it distorted and exported the competitive issues which they complained of, and which was the rationale for introducing this selective application of this tax.
Mr. O'Neill, can I ask you a question, please? Did LVCR apply to imports from France to the United Kingdom?
No, it did not, because the principle of VAT as it now exists is that the VAT is charged on by the state of origin, and so it should not be recharged when it comes into the state of import.
I see.
So that's a different.
I see.
Different
so if a supplier in France supplied goods to a purchaser in the UK, it would bear French VAT.
It would have borne French VAT, yes.
I see.
So what you're complaining about is not the imposition of a charge, but the removal of a special preferential treatment.
No, what I'm complaining about is the selective, because one looks at the reality and what the economic effect is of what is happening here, and although formally one might say, oh, all we've done is removed an exemption that you previously had, what in fact has happened is that goods that were previously not subject to a charge are now subject to a charge just because they come from the Channel Islands, whereas goods which those same goods which might come from the Åland Islands or the Canary Islands are not subject to that charge. So the economic reality is a charge has been placed on particular goods because of their origin.
But
and the Court of Justice tells us to look at the reality of things.
Mr. O'Neill, it seems to me to be right to follow from that until the removal of LVCR in 2012, supplies from the Channel Islands were at a competitive advantage compared with supplies from France.
But that was what was allowed for and required under EU law, because
Mr. O'Neill, when you say it was required under EU law, what are you referring to?
I'm referring to Article 23 of the.
But that doesn't require it, does it?
That permits it.
It says there should be an exemption. That's the VAT Exemptions Directive, but it allows for the potential option of it being removed by member states in relation to mail order distance selling goods. But my point is that because this is the exercise of a discretion under EU law, it is not one which can be exercised contrary to the principles of EU law. It has to be, if you're going to disapply it, then you have to disapply it compatibly with the principle of equal treatment. It doesn't allow for what we will, precisely because all of the trade law, internal trade law of the EU says you do not make a disapplication of an issue because of under reference to origin.
Mr. O'Neill, Mr. O'Neill, could I just follow up my Lord Richards' question? If a French supplier in the same position as your clients was to make a supply of seeds in a packet to an English domestic buyer,
yes,
are you saying that the English domestic buyer would pay French VAT?
The VAT would already have been paid on, as I understand it, and therefore it would not be liable to UK VAT.
But
how would be the French VAT rules that applied?
How would the French VAT have already been paid prior to the seeds arriving in the hands of the English supplier?
Well, part of the price, I think. Well, in other words, it would be part of the price, wouldn't it, that the French supplier charged? So, as I understand what you're saying, Mr. O'Neill, the French supplier would account to the French VAT authorities for the VAT that it had charged on that sale.
We're talking about supplies to an end consumer here.
Yes.
Yes.
And the whole point about the VAT is that it shouldn't be charged twice. So the UK doesn't charge VAT on that. Now, the position from the Channel Islands and the Åland Islands is different because, of course, they don't charge VAT internally. because they're outside the VAT area. So in that sense, yes, it could be said that those territories outside the VAT area, which are within the internal market, have a form of a competitive advantage. But that is what EU law has allowed for. Now, if you want to take away that competitive advantage, then there are procedures for doing it. And it is useful in that regard to see what was done. We have a direct case study on how you do it lawfully from the position.
Well, where are the procedures set out? What's the law that you're saying imposes these procedures?
I'm sorry, I missed that.
Are you saying when you say there's some procedures for doing it, what are the legal requirements you're referring to there? Where are they to be found, these legal procedures?
Well, I'm just taking the court.
You're going to show us, right?
Yes. And it's the case of Denmark, which had an issue about magazines being imported from the Åland Islands. And therefore, were effectively not having VAT charged on them. So it's a directly analogous situation to what happened in this case. Now, in the Danish authorities' case, when they discovered that publishing companies were rerouting the magazines and periodicals via territories which weren't covered by the six VAT directives that then was, that was namely, what was happening is that magazines were being sent to the Åland Islands, which would then send them on to Denmark, and VAT would not be paid on them. And that was causing a significant loss of VAT to Denmark and also indirectly to the EU. So they then applied to the Commission for a derogation as to what their obligations might be. And that's set out in the explanatory memorandum by the Commission, because the Commission took on board the facts that Denmark set out and then proposed that the Council have a specific decision allowing for a derogation from the otherwise general obligations in relation to VAT.
But if you're right that this selective disapplication of the low-value consignment relief is contrary to the general principle of equal treatment, can that be overridden by a Commission decision? Wouldn't that mean that the Commission decision in the Danish case is actually unlawful?
No, because the point about equal treatment is not an absolute principle. It is one treats like goods alike.
You're saying that the Danish...
except insofar as there's justification.
Yes, but you're saying that the Danish answer was to arrive at a result where there was a selective disapplication.
But it was by reason of, and I'm coming on to it, and I'll point out the particular facts, it was by reason of the fact they were given a specific derogation by the...
Yes.
So on the recommendation of the Commission. So what that meant was that the EU legislature had come in and said, looking overall at the internal market, saying actually when one looks at it, the best way of achieving the ultimate aims of the treaty, which is undistorted competition, in this case, is to allow for a particular derogation. Now, as I've said, equal treatment does not mean...
Mr. O'Neill, can I just follow up, please? Do you have a case that you can show us which says that a Commission decision can approve something which would otherwise be a breach of the general treatment of equal treatment? Because I'm not sure that they can.
Well, that's why I'm showing the Danish case, if I could get to the documentation which applies to the Danish case. But my point is, if I can just prefigure my approach, is that the principle of equal treatment is not an absolute principle. It is you treat like cases alike unless there is justification for different treatment of like cases. And in this case, the justification as a matter of EU law is that the member state has not acted unilaterally and has been given specific permission by the EU legislature to act as it did. And that would be sufficient justification, I suspect, before the Court of Justice to allow for this otherwise unequal treatment.
Well,
it's not a commission decision, it's a council decision.
Yeah, either the equal treatment is justified or it isn't. Either the unequal treatment is justified or it isn't. But I'm not sure that the Council has any greater ability than a member state to determine that.
Well, in that we have to disagree, because the whole point about the Commission and the Council is to take the broader view of what the internal market as a whole requires, rather than the member states, which will necessarily simply look at their own domestic situation. That's why one applies to the Commission, and it makes a recommendation, and the Council acts, because they get the view from above of the internal market as a whole and what the objectives of the treaty require in order to achieve the ultimate end of an internal market without internal borders which distort competition or impede free movement of goods. So yes, it does make a difference. But I will come on and specifically refer the court to, if I may, the Danish materials. So first of all, there's the explanatory memorandum of the Commission, which is at page 644, tab 37. And it says, this was based on the Article 14.1d of the 6th VAT Directive. And it says, the Commission says that article stipulated that member states shall exempt the final importation of goods qualifying for exemption from custom duties other than as provided for in the Common Customs Tariff. And that had been implemented by the then Directive 83/181, which is now Article 23 of the VAT Exemptions Directive. And that stipulated that the goods of a total value not exceeding, in that case, €10 shall be exempt on admission. It then noted, under the provisions of the statute, member states may grant exemption for imported goods of a total value of more than €10, but not exceeding €22. However, member states may also exclude goods which have been imported on mail order from this exemption. So it's precisely the Article 23, what is now Article 23 of the VAT Exemption Directive. Denmark currently exempts imports of small consignments with a commercial nature from outside the EU from VAT. The Danish limit is €10. However, the Danish authorities have discovered that publishing companies reroute the distribution of certain magazines and periodicals via territories not covered by the 6th Directive, i.e. within the EU, but not covered by the 6th Directive, because the 6th Directive will not cover and demand VAT from outside the EU, because it's about the Åland Islands. So it's like the Channel Islands. According to the investigation, the Danish authorities note that 3.5 million weeklies and magazines were imported into Denmark from the Åland Islands, meaning a loss of revenue of €6.2 million. There's a risk a loss of revenue will increase unless the VAT rules are amended to prevent this tax avoidance. Denmark's losses of VAT revenue will also have a negative impact on the community's own resources. Since the introduction of the then VAT Exemptions Directive, member states no longer have the option of not granting the exemption for these imports on the basis of their concerns that the exemptions would be liable to have a serious effect on conditions of competition on the home market. That is precisely the grounds upon which the UK claimed to selectively disapply the LVC in this case. But the Commission goes on, the Danish government cannot establish whether these imports have a serious effect on conditions of competition, but the request for derogation only targets the consignments and scenarios subject to the avoidance scheme and does not intend to exclude all mail order consignments on the basis of Article 22. So that's important. You see, it's a targeted measure which is being suggested by Denmark. It's not all mail order, and it's not all mail order from the Åland Islands. It's targeted to those consignments subject to the actual avoidance. It therefore appears to the Commission that the envisaged derogation from Article 14.1d is in fact the most appropriate solution, and for the particular tax avoidance scenario to be addressed, the derogation avoids the loss of VAT. And the result of that Commission recommendation is that Council decision was made, which is found at page 645 of the bundle, tab 38.
645?
Which is just one, 645.
Thank you.
That just has one article, and that says, by way of delegation from Article 14.1d
Sorry,
of...
you're reading at which point?
Article 1 of
Article
page
1.
645.
Thank you.
Sorry. Sorry, I'm
Got
trying to juggle paper and... Yes, it's Article 1 on page 645. By way of delegation from, so a delegation from the otherwise general requirements of the VAT directive, Denmark is authorised to apply VAT on the importation into Denmark of magazines, periodicals or the like, so the actual goods that were the subject of the tax avoidance, which were printed in the territory of the community as defined in Article 3 of the directive. And the territory of the community as defined in that directive is the customs union or the customs or the internal market, i.e. it includes the Åland Islands, as you would expect, because of course the goods are coming in from the Åland Islands and sent to private individuals. So, what's important from this is that we have...
Can you just clarify? Would the derogation in Article 1 cover magazines that are actually printed in the Åland Islands?
Yes, because it is printed in the territory of the community as defined in Article 3 of the said directive, and that is basically a reference to the territories within the customs union and excluding simply those territories that were associated with member states that were outside the customs union. What are now Article 6.2 of the Principal VAT Directive territories. But the territory of the community as defined there is basically what is now Article 6.1 and Article 5 territories of under the Principal VAT Directive. So yes, it would cover those printed in the Åland Islands. So what we can learn from the Denmark case is this.
So it wasn't limited to round tripping then?
It was anything that was printed in the territory of the community as defined. They were allowed to apply VAT on it. So if it were printed, it wasn't limited to the Åland Islands. But what it was limited to was magazines and goods and periodicals. So it's categories of goods it was limited to, not origin within elsewhere in the territory of the European Union. VAT was allowed to be applied to all imports into Denmark of magazines which were printed in the territory of the community, the Åland Islands as well as elsewhere. So it caught...
So the answer to my lady's question is that it was not limited to round tripping.
No, it wasn't limited to round tripping, but it caught round tripping. But it caught round tripping, and this is important, it caught round tripping.
I'm sorry to interrupt. Did it catch round tripping?
Yes, it did.
Because the magazines had to be, it says, it's a derogation to authorise the application of VAT on the importation into Denmark of magazines, periodicals, or the like, printed in the territory of the community. Yes, I follow. So that means Denmark or wherever. Yes, I see.
That means the Åland Islands, it means Sweden, it means whatever the community was at the time. But it's the Article 6.1 to it mean the Channel Islands too. So it stopped round tripping, but it wasn't limited to round tripping. But the important reason we've got for that is because it does not, the derogation does not make a difference according to where in the customs union or the territory of the internal market the goods are coming from, because that would be in breach of free movement. What it does do is apply to just magazines and periodicals, i.e. to a particular category of goods. So the point about the derogation is it complies with, to answer Lady Rose's concerns, with the fundamental principles of free movement of goods and non-distortion, which is that you do not apply it selectively to goods which come from particular territories by reference to their origin, but you do apply it comprehensively to particular categories of goods which are apparently causing distortions in the market in order to stop that distortion of the internal market.
But it was common ground, wasn't it, between Denmark and the Commission, because I think it's the only way in which this all makes sense, that the Islands were part of the community.
Yeah, there's no doubt about that, but yes, of course, absolutely. And the Islands are part of the community, and as are the Channel Islands. And but that was the case when the Islands were outside the VAT directive, because clearly they've said it's imported from territories where the 6th directive doesn't apply, and that's why you get the VAT advantage. So this case is on all fours with the present case, but it shows how one can act lawfully and what you do is you put your case to the Commission, saying there's a distortion of competition within the home market, but clearly distortion which leads to a loss of VAT. The loss of VAT for Denmark means has an impact on the resources of the community. The community then takes a decision at community level as to what is the best way of dealing with this loss of VAT and the distortion of the market, and it does so by reference to a derogation which makes no reference to origin within the community, but allows VAT to be imported on all those imports if they are magazines or periodicals which have been sent directly to private individuals.
What's slightly puzzling me about this is that in recital 3, it states that the discovery of the rerouting of publications to subscribers in Denmark via territories, well, that's the islands, not covered by the 6th directive.
Yes.
So if that's not covered by the 6th directive, then when Article 1 refers to magazines printed in the territory of the community as defined in Article 3, we're talking about different areas here, are we?
Yes, because I mean, we're not. We don't have the 6th VAT directive before us, but basically what that means is when it refers to in the territory of the community as defined in Article 3, as I've said, Article 3 of the 6th VAT directive defines the community as the customs union area, which is to include the Åland Islands and the Channel Islands, as well as the member states more generally. That's how that definition is. What in the principal VAT directive is now Article 6.1 plus the member states as defined in Article 5. So that's what they mean by community, and then they say it's territories not covered by the 6th VAT directive means those territories, the Åland Islands and the Canary Islands, which although they are within the community as defined by Article 3 of the directive, are not covered by the VAT obligations. They're outside the EU VAT area. So, as I say, it's on all fours with our case. But as I say, what we can see from that is that the proper approach, which is consistent with EU law, is this. First of all, it tells us that member states did not have the option unilaterally to impose import VAT, what would be called import VAT on goods which were otherwise exempted from EU customs duties, because of the concerns about competition distortion in the home market. Instead, those concerns had to be taken to and set out before the Commission, which could then look at, examine the facts, and then make a recommendation to the Council, which had the competence to legally to allow for a derogation from another provision of EU secondary law in VAT, and allowed by that derogation VAT to be charged on all imports of magazines and periodicals.
But isn't the difference here that the exemption for magazines and periodicals under the 6th directive was a mandatory one, whereas the exemption for low-value consignment relief is, as far as mail order is concerned, a discretionary one at the discretion of the member state? Doesn't that make a difference as to whether you...
No, I don't think that's right. That's, lady, with respect, in that they've quoted the 6th VAT directive provisions in the explanatory memorandum, which we've just looked at page 644. It says member states may grant exemption for imported goods of a total value of more than €10 but not exceeding €22. However, member states may also include goods which have been imported on mail order, exclude goods which have been mail ordered from this exemption. So it's exactly the same provision as Article 23. That's what they're applying here. So there isn't a distinction. So, but the important thing is, and this is
Article 23, Mr. O'Neill, goes on to say that member states may exclude goods which have been imported on mail order. So
yes, and
doesn't that make it discretionary?
But I'm sorry, but that's exactly the provision that we're talking about here in the Danish case. However, member states may also exclude goods which have been imported on mail order from this exemption.
Right.
It doesn't say anything about it doesn't say anything about getting the authority of the Commission, does it?
Yes. The point is that the authority from the Commission is needed because they were now going to be claiming VAT on magazines which were imported from anywhere within the customs territory, not just the Åland Islands, but also from Sweden or France or whatever. There probably were very little, so it didn't matter. But they then had the authority to stop that. They needed the authority of the Commission because they wouldn't be allowed otherwise. They needed a derogation for the requirements of secondary VAT law because they wouldn't otherwise be entitled to charge VAT on magazines coming in from France.
Why in that case does this example help us in the present?
Because it's direct, it's on all fours with our case.
I thought sorry to Mr. O'Neill. I thought you just told us that this council decision enabled Denmark to impose VAT on imports of magazines from anywhere within the single customs area. That's to say,
yes,
in Sweden or France or whatever. Whereas this case, this case is not concerned with that. It's concerned with imports from one of the third territories, I think they're called.
And
so it is it's a rather, so I say, why is it on all fours with our case?
It's on all fours because it's the same economic problem which is identified as round-tripping. The VAT is being avoided by use of territories within the internal market but outside the VAT area and using imports from that. And the point about it is, and in a sense the question has highlighted the solution. The solution which EU law allows for is not for the VAT or the VAT to be selectively disapplied, the VAT exemption selectively disapplied and applied only to goods depending on the fact that they come from the Channel Islands. What it requires is that instead you do not make any reference to origin anywhere within the customs union, yes, because it's all there free. I'm sorry, and you do not make any reference to origin within the customs union, but you do make reference to the specific category of goods which are at issue, which have caused the problem.
Is it right that, as I think my lady was saying a moment ago, that there was, I mean, as a basic principle, there was no VAT on magazines?
No, there was VAT because that's the whole point. They have lost VAT because it's being imported via the Åland Islands.
No, forgive me, I think you misunderstood my point. But for this, I mean, as a general proposition, was VAT chargeable at all on magazines?
Yes, because that was the problem which the Denmark went to the Commission about. They said that these magazines, because they're going through the Åland Islands, are not getting VAT on them. So therefore, there's an issue. Now, what the Council decision is not then saying, oh well, you can charge VAT on goods coming from the Åland Islands. It says you can charge VAT on magazines and periodicals from anywhere within the within the customs area, which is to include the Åland Islands. So it makes a decision on the basis of not making any reference to origin because it's conscious of seeking to maintain equal treatment within the customs union to ensure free movement of goods. And it is a proportionate and targeted response because it only deals with the particular goods which were being imported, which resulted in the VAT losses complained of, that is magazines and periodicals. So that shows how one goes about it. You don't refer to origin within the European Union single market, but you can refer to categories of goods which are causing a problem, and the Commission can be convinced then, if there is a problem, to recommend to the Council, which can then make a decision. And of course, the Council is all the Member States acting together when it comes to VAT, it's unanimously, to derogate from the particular issue.
Mr. O'Neill, can I trouble you just once more? Is Article 3 of the 6th Directive copied in your authorities bundles? I'm just looking at the index, and there's been selective copies from that directive, but I don't think they include Article 3.
No, they don't. Of the 6th VAT Directive, we can get that to the court. I mean, I have in the speaking note, I've taken my own note of it, but it wasn't produced to the court, but that can be produced. But what it says is that for the purposes of this directive, the territory of the country shall be the area of application of the treaty established. Anyway, it excludes from the territories of individual territories the Federal Republic of Germany, Island of Helgoland, Usingen. Anyway, it excludes the Article 6.2 territories, but it includes the Article 6.1 territories. But later on, that's what Article 3 does in the 6th Directive, but later on, clearly, there is a definition of the VAT territory, which means that the Åland Islands are not in it, because that's why it's got the that's why you get the VAT advantage from going through the Åland Islands.
So, sorry, are you saying that at the time of this directive, the Åland Islands were or were not a third territory, or whatever, an outside territory?
They were in the same position then as they are now. They were not within the VAT area, because and it's because of that, because they weren't within the VAT area as defined in the 6th Directive, that by routing them through the Åland Islands, you got the VAT advantage. They were within the customs union and internal market, because that is what the treaty, the provisions in terms of the accession of Finland provided for. So they are exactly like the Channel Islands, and they remain exactly like the Channel Islands. That's why it's as important. This issue of how Denmark dealt with matters and how the Council and Commission dealt with it is importantly on all fours, because it's the same economic problem, and the contrast with what the UK did is stark. What the UK did is that it didn't make any application, as far as we know, to the Commission, setting out its case, allowing it for a derogation from its VAT import VAT obligations under EU law. Instead, it purported unilaterally to impose what it called import VAT on low-value goods, which would otherwise fall within the category of those which might be exempted from import VAT. And they did that unilateral withdrawing and selective withdrawing on the claim grounds that the maintenance of the exemption from import VAT had a serious effect on conditions of competition in the home market. But they didn't offer to prove this to the Commission in the way that Denmark did. The imposition of what was called import VAT was made under reference to and only to origin, i.e. it applied to all goods coming in by mail order from the Channel Islands, to all low-value goods being imported in from the Channel Islands. Now, that's not the solution that was allowed for in the Danish case. They didn't seek to stop all and any imports, low-value goods, entitled to VAT exemption from the Åland Islands. But that's what the UK does. It refers to that origin in and only in the Channel Islands.
But is the reason, I mean, the reason why Denmark sought this derogation is because they were not proposing to apply VAT to all mail order goods. I mean, isn't it right that they couldn't use the power given by the relevant article, like the power in Article 23? I mean, 23 allows member states to exclude goods which have been imported on mail order. So that would be all goods. But what Denmark wanted to do was to apply VAT only to magazines which had been bought by mail order?
Well,
is that? I mean, I'm asking you really, but I was wondering whether that's what recital 4 to the Council decision is referring to.
no, what that's referring to is that Denmark has specifically pitched its proposal so that it is proportionate and the least.
Well, I understand that, but what Mr. O'Neill, what I'm really confused about at the moment is whether it is your case that in order to remove the exemption as regards the Channel Islands, the UK was required to make a similar application as that made by Denmark. I mean, if that is your case, it's a very simple case, but I haven't really discerned that from your written case, that is your fundamental proposition.
The fundamental proposition is that what the UK did was in breach of EU.
I know, but are you saying, forgive me, are you saying that the UK was required to go and seek derogation from the Commission? And if they had followed this procedure, then that would have been lawful, but a failure to follow the Denmark-type procedure makes it unlawful. Is that your basic point?
No. What I'm saying is that the Danish case shows how the same economic problem could be and was dealt with lawfully. I'm not saying it's the only way in which that economic problem could have been dealt with lawfully, because another way, potentially, would have been the withdrawal of all the VAT, of all LVCR from all goods coming from elsewhere in the customs territory, i.e. from the Åland Islands as well as from the Channel Islands. So there are different ways that could have been done, but all that one does know, and the Danish case illustrates that, is what the UK did was unlawful.
So you're relying on this not to say that you need the Council's decision, but to show that when there was a particular problem with the Åland Islands, the solution was not to disapply the exemption from the Åland Islands. It had to be done across the board. But,
yes, it
but
could
I think you
be taken away, and it could either be taken, but in terms of across the board, it could either be done theoretically under Article 23 by withdrawing it from all the territories that would otherwise be liable for import VAT under Article 30 of the Principal VAT Directive, which also fell within the customs territory, i.e. the Article 6 territories. You can withdraw it from all of those, and so therefore you're not exporting a distortion into the internal market. Or else you can do, as Denmark did, and said, well, actually what we're going to do is, in terms of a particular category of goods, the Council is going to allow us to charge VAT on all imports coming in from elsewhere in the customs territory, regardless of origin. So there are different ways of doing it. All that one is saying is that what was done here was not lawful.
Yes.
What was done?
Do you accept that if the UK government had decided to lift the relief from all the third territories, they could lawfully have done that without getting a council decision?
In principle, yes, I think that's right, because that's what Article 23, in a sense, does. It leaves, because VAT is not a wholly harmonised system, it's becoming more and more harmonised over time, but it does allow for the possibility of the disapplication by a member states. But what it does not allow is this selective disapplication by reference to origin, because we know that reference to origin is a way which origin within the internal market is a manner which then introduces distortion into the internal market. And the whole point about Article VAT is that it shouldn't allow for distortion being introduced into the internal market. That's what Article 113, its legislative base, says. That's what Article 1110, internal taxation, says. And that's what Article 30, in terms of fiscal charges having equivalent to customs duties, says. You cannot make reference to where in the customs territory the goods came from. So, but the other alternative would have been the prudent Danish approach and just get clearance first, rather than risking it with unilateral action. Because in a sense, the Court of Justice, perfectly understandably, is not keen on unilateral action by member states, and it's been closed down in the area of the free movement of goods, and it's been the possibilities of being ever closed down as that develops into the system it's intended to be, which is uniform taxation throughout the territory of the internal market, so as borders will not be allowed. The delay in reaching that is because VAT is still covered by the requirements of unanimity in the Council in order to get measures across. So, as I say, the Danish example is useful because it shows how it could lawfully be done, and it shows and it highlights how it was that the UK acted unlawfully. It didn't make an application to the Commission. It purported unilaterally to disapply the exemption. It did that disapplication to all and any goods, i.e. not just the goods which were the problem, the round-tripping problem, because the horticultural goods in this sense certainly were not, and that's common ground. They were grown in the Channel Islands. They weren't imported from the UK, then exported out again. So the disapplication was made under reference to origin. It only applied to low-value goods imported from the UK, into the UK from the Channel Islands. And at the same time, the UK maintained the exemption for goods coming from elsewhere within the customs area, namely the Åland Islands and the Channel Islands. So it was made under reference to origin, it wasn't made under reference to categories of goods, and it covered goods which were not the subject of the abusive practice of round tripping. So, that is in essence the case which HMT have been called to answer. But they don't answer it. And all they do is mischaracterize and misrepresent the case that's made against them. And there are two main bases upon which this misrepresentation is made. But the fundamental position which they seek to say is that equal treatment, the principle of equal treatment, has no application to goods coming from the Channel Islands. So therefore, their selective disapplication is permitted as a matter of EU law. And that's a clear blue water between us. Now, as I say, there are two main lines of defence which are set out in the case from Majesty's Treasury to that effect. And they are this. First of all, HMT suggests that the Channel Islands are not within the EU for the purposes of that. That's the basic thing. And because we have accepted that the principle of equal treatment can't be applied in external relations law by the third countries outside the EU, then the HMT position is, well, gotcha, because the Channel Islands are a third country for these purposes. It's a line of defence which I've called the Schrodinger's cat defence, because what the HMT are saying is that the Channel Islands is at the same time inside the EU and outside the EU. And for the purposes of VAT, it's outside the EU, and therefore it cannot claim the principle of equal treatment. Now,
is that quite a fair description of the respondent's case? I think my reading of it was that they say the Channel Islands are not in the EU. They are not a member state or part of a member state, but they're simply treated as if they were for purposes of customs.
Yeah, and that's wrong. I mean, if that's an elaboration of what they're saying, then that's equally wrong. Well, but I don't think they are saying
firing at the right target, Mr. O'Neill.
No, I'm finding it, well, it's difficult because it moves around, but I will, I mean, I'm trying to make sense of what's said in their case. But that would be wrong as well if that's how one interprets the case, because that's suggesting that in some sense the Channel Islands is an independent territory which has entered into an association agreement via the terms of Protocol 3 of the Treaty of Accession of the UK. It hasn't done that. The Channel Islands are and always are a dependent territory. They're not independent. They're not able to enter into international agreements. They have no international personality, and so therefore they cannot be said to have entered into anything equivalent to an association agreement like a non-member state might have, like the UK has entered into in its trade and cooperation agreement. So that's fundamentally wrong in the first place, but I think what they're trying to say is that, oh well, because there are cases in which the Court of Justice has undoubtedly treated the Channel Islands as within the EU, but somehow for that purposes they're outside the EU. I think that is what they're saying, but it's and that's why I'm calling it Schrödinger's cat, because it does capture they're both inside and outside at the same time, depending on which box or when one decides to open a particular box to see whether the cat is alive or dead.
Well, my understanding was that in the Channel Islands, they don't have to apply VAT to supplies within the Channel Islands.
That's correct.
Well, so then why is it that you say that they're not outside the VAT area?
No, I didn't say they're not outside the VAT area. I said they're not outside the community. They're not outside the European Union. They are within the internal market. They are within the customs union. But the principle of variable geometry applies in this case as it applies to many other territories. So just because one is a territory within the EU doesn't mean to say that every aspect of EU law applies to it. And
I wonder, Mr. O'Neill, whether rather than referring to a territory being in or out of the European Union, would it be more accurate to consider the extent to which the treaty provisions apply?
Yes, and the treaty, and I'm going to do that. I mean, I'm more than happy to do that because they support my position. First of all, the treaty provisions do not allow for the Channel Islands becoming a third territory outside the EU, such as the HMT claims. We know this from the Jersey produce marketing case, among others. That's to be found at page, it's tab 69, page 1376. And in the judgment at page 1415, the Grand Chamber of the Court of Justice confirms that because the Channel Islands are a European territory for whose external relations the United Kingdom is responsible, the foundational treaty default position is that the Channel Islands are included as a matter of law within the EU. That's the provision which is now Article 355, subparagraph 3 of the Treaty on the Functioning of the European Union. That's to be found at page 632. And that says this: the provisions of the treaties shall apply to the European territories for whose external relations a member state is responsible. So that says the treaties shall apply. That's the default foundational position.
Sorry, where are you reading?
Article 355, subsection.
I see. I thought I was
632.
I was just looking at the judgment you took us to, which I was finding quite helpful.
Which passage in the judgment are you referring to, Mr. O'Neill? We have it at page 1415.
Right, I'll just find that.
Is that the Jersey?
Yes.
1415.
Sorry, that's what you took us to. You referred us to it. So.
Yes, I did. Apologies for I was then taking one.
I'm looking at paragraph 38. I'm sure that really...
Well, I think it really starts at 42, probably, but I may be wrong.
Yes, my lord.
Got a heading just above.
Yes, it does. Yes, the referring court explained in the context of a previous case, Jersey as a semi-autonomous dependency of the British Crown, represented in Jersey by the Lieutenant Governor. The UK government, on behalf of the Crown, is responsible for defence and international relations. Jersey doesn't form part of the United Kingdom. It's for the purposes of Article 2994, a territory for whose external relations the member state is responsible. That's now, as I've said, Article 3553. So,
well, I think paragraph 44 is quite relevant.
Yes, and I'm coming on to that.
Oh, I'm sorry.
Yeah. So, as I've said, the default foundation is that the provisions of the treaty shall apply to European territories for whose external relations are responsible, member states responsible. So the Channel Islands fall into that category.
Okay, but read on.
The Channel Islands.
Mr. O'Neill, read on. That's why I referred to paragraph 44.
I am doing that, my lord. I am aware of that. I'm explaining.
So that's a 2996C is a derogation from 2994, isn't it?
And it's now Article 355, subsection 5, subsection C at page 632. What it says is that what the article now says, and I'm looking at how the law now applies, notwithstanding Article 52 of the Treaty on the European Union and paragraphs 1 to 4 of Article 355, the treaties shall apply. So again, the default is the treaties shall apply, but only to the extent necessary to ensure the implementation of the arrangements for those islands set out in the treaty concerning the accession of the UK. So what that's saying is that the treaties do apply, shall apply, but that certain aspects of them will be disapplied, and it will be under the criterion of, is the disapplication or the application necessary to ensure the implementation of the arrangement set out in what is now Protocol 3. Now, neither Article 355(5)(c) nor Protocol 3 sets out what those provisions are. There's no specific listing of what is to be disapplied. Instead, it's the general test of what is necessary to ensure the implementation of the arrangements. The Protocol 3 is set out at page 640 to 641, and that says in Article 1, the treaty rules on customs matter and quantitative restrictions shall apply under the same conditions as they apply to the United Kingdom, and then goes on about agricultural matters. And at the end of Article 1, it says, the Council, acting by a qualified majority on a proposal commission, shall determine the conditions under which the provisions referred to in the preceding subparagraphs shall be applicable to territories. So, as I've said before, just because the treaties allow for the disapplication or the selective application of aspects of the treaties in relation to particular territories, doesn't mean that for the purposes of for those purposes, the territory or the state is somehow outside the EU, and that's what that's the basis of HMT defence. And all one needs to point to on this issue is, for example, the Schengen acquis. The Schengen acquis does not apply to Denmark, to the UK, or to Ireland. We know that because Protocol 19 of the treaty says that. But that doesn't mean to say that for the purposes of the application of the Schengen Accords, Denmark, the UK and Ireland are to become third countries outside the EU, or its citizens become not EU citizens. All it's saying is those aspects, the Schengen aspects of the treaty, don't apply. But the UK, Denmark and Ireland are still member states. They can still, for example, take a case before the Court of Justice saying that the Schengen Accords are invalid because they're beyond the limits set out by the treaty. They've got standing as member states. They don't become Schengen non-member states. Similarly, we've got the provisions in Protocol 21 and 22 which disapply certain provisions regarding the EU Common Area of Freedom, Security and Justice from the UK, Ireland and Denmark. Again, that doesn't mean that they are non-member states for the purposes of the EU Common Area of Freedom, Security and Justice. And then, more pertinently perhaps, the Eurozone. Not all member states are members of the Eurozone. They haven't all adopted the Euro. Bulgaria, the Czech Republic, Hungary, Poland, Romania, Sweden and Denmark and the United Kingdom didn't adopt the Euro. They're outside the Eurozone. Being outside the Eurozone does not make them equivalent to third countries outside the EU for Eurozone purposes. We know that, for example, that the the United Kingdom could and did successfully challenge decisions of the European Central Bank, even although it wasn't under the jurisdiction of the European Central Bank. We have a case on that in the supplementary bundle at tab 6, page 140. Then we've also got other examples of variable geometry of the, notably Protocol 35 refers specifically to Ireland, and that nothing in the treaties shall affect the application of Article 40.3 of the Irish Constitution. So all that's about then is the variable geometry of EU law. Territories within the EU don't necessarily have every provision of the EU law applying to them. What EU law doesn't talk about is variable geography. That's what HMT are saying. Who's a member state or what is within a member state varies depending on whether a secondary principle of EU law or even a treaty provision applies to it or not. There is no basis for that. There's simply no case, and it's actually incoherent because it's, in the case of Denmark, in the case of the Channel Islands in particular, it runs contrary to the basic provision, which says that the treaties shall apply, except if and insofar as disapplied. Just like the protocols on the Eurozone, on the Schengen area, and on the area of freedom, security and justice do for other member states. The second point is...
Well, in fact, Mr. O'Neill, what it actually says is the treaties shall apply to the Channel Islands only to the extent necessary to ensure the implementation.
Treaties shall apply, yes, but the basic position is only to the extent necessary. You need to apply a test of what is necessary. I'm going to come on to what is necessary for those purposes. So, it's said, they say that the Channel Islands are excluded from the VAT area by secondary legislation, not by treaty provision. That's the second attempt at the Schrödinger's cat defence, because they say at page 130 of the case, at paragraph 4, legislation couldn't apply to the Channel Islands since the Treaty on Functioning European doesn't extend to them in that regard. It's a matter of treaty law, not merely secondary EU legislation, that the Channel Islands were outside the EU, and that situation reflected in rather than caused by EU secondary legislation. But there is nothing in any treaty provision in the Treaty on the Functioning European Union which defines the VAT area. There is no provision that says, treaty provision that says the Channel Islands are at all material times outside the VAT area. There isn't any express provision that says that. There's nothing expressly said about VAT at all, in fact. Well, there's a reference in the treaties.
But it says, it does say in Article 52, Article 52(5)(c) that the treaties shall apply only to the extent necessary to ensure the implementation of the arrangements. You then go on to look at the protocol, and that identifies certain matters that are necessary for inclusion.
Yes, and identifies the possibility.
VAT is not one of them.
VAT is not expressly made one of them. That doesn't mean to say that it doesn't apply, and we know this because the Isle of Man is covered by that very same protocol number 3. It applies equally to the Channel Islands and to the Isle of Man, but the Isle of Man is within the EU VAT area. So therefore there is nothing contrary to, within the terms of any treaty, which says that the Channel Islands have to be outside the VAT area. It's clearly...
But the Channel Islands have for many years operated on the basis that they are outside the VAT area by not imposing VAT on their internal supplies. I'm not quite sure what you think this proves.
I'm sorry, milady.
Prove that they've been acting unlawfully all this time by not charging.
Not at all. I mean, sorry, I have made it plain that we know that the Channel Islands are outside the VAT area. That's what Article 6.2 says. But what I'm saying is that that is a reason because of secondary EU law. The Treasury say it's because of primary EU law, because of the treaty. I'm pointing out there is no treaty provision that puts them outside the VAT area. I'm not denying they're outside the VAT area, but they're outside the VAT area because of secondary EU law. And the point is that the protocol number 3 doesn't put them outside the VAT area because the protocol 3 is habile to allow for the Isle of Man being in the VAT area. So yes, they're outside the VAT area, but because of secondary law, Article 6.2, not because of primary law. So that's the point. I'm trying to take from that. Because it's all to do with building up a case that the Channel Islands are not a member state for VAT purposes, which is wrong. They are part of a member state in which the VAT requirements are disapplied for that territory for the purposes of EU secondary law. But it doesn't say that they are non-member states. It doesn't say, therefore, they can no longer rely on general principles such as equal treatment. That's the point I'm trying to get across. So, what they do try and say, however, they say this at paragraph 4 of their case at page 130, once the appellant expressly accepts the principle of equal treatment is not applicable to relations between the Union and non-member states, it asserts that Jersey was not outside the EU. That is wrong, says. Certain revisions of the treaty applied by virtue of the protocol, but that didn't make it an EU member state. Well, we've never said that it's an EU member state. Of course it's not an EU member state. The point is, it is a territory associated, it's a European territory for whose external relations the UK is responsible, and by reason of the UK's membership, the Channel Islands becomes part of the EU and the treaties apply to it. Now that is absolutely clear from the case law, but if one wants a particular reference, the Rock case, which was referred to in the Jersey Produce case, which is in the supplementary bundle at tab 4, pages 75 to 76, the Advocate General has a useful survey.
I'm sorry, you're going to take this a little more slowly. The supplementary bundle, page?
4, page 75 to 76.
And what's the authority?
It's Rock against Jersey.
Bear with us while we change to the other bundle. Yes, paragraph 4, did you say?
Of the Advocate General's opinion, yes, at page 74. In paragraph 3, he sets out the position under UK constitutional law. But he then goes on to consider the position as a matter of EU international, general, public international law. And he says, furthermore, Jersey and the other British islands, i.e. the Isle of Man, do not have international personality understood as the power to act independently, and thus constitute, for international law purposes, mere territorial subdivisions of the United Kingdom. While that conclusion appears at first sight to be incompatible with the paragraph 3 observations on the relations between Jersey and the UK in terms of its internal constitutional law, the contradiction is merely apparent. The unusual constitutional position reserved for the British Islands may be regarded merely as a form of self-government laid down by the domestic constitution of the United Kingdom in relation to a part of its own national territory. So for the purposes and from the viewpoint of EU law and public international law, Jersey is part of its own national territory. So it is a region of the United Kingdom, despite HMT claiming to the contrary. Even if it isn't as a matter of constitutional law, it is as a matter of, from the perspective of EU law.
But were you submitting that result is arrived simply because the UK is somehow responsible for the international relations of the Channel Islands?
No, because we're told that that is the default position under 3553, that it's a dependent territory. It's not an independent territory. It has no international legal personality, and it is a European territory. So it does fall within the terms of squarely within 355C. So therefore, as a result of that, special provision is made, given that the treaties apply, what parts might we disapply, and then Protocol 3 of the 1972 Accession Treaty is entered into. The other points that doesn't make it. And
Mr. O'Neill, reading on in the Advocate General's opinion, he does seem to be saying that under public international law, treaties are assumed to apply to all territories for whose international relations each contracting state is responsible.
Yes.
But if that was so in relation to the EU, that would mean that the Cayman Islands were part of the community, which,
No,
I mean,
because Article 355C says European territories.
But, I mean, I think the passage my Lord was referring to, the position is explained, isn't it, that under public international law, treaties are presumed to apply not only to national territories, but to all territories for whose international relations each state is responsible, save where that presumption is superseded. And that's precisely what's happened here. So we just seem to be going round in a circle, Mr. O'Neill.
No, we're not, my Lord, because the presumption is superseded by Article 355C, or 3553, which says that European territories shall be covered by, the European treaty shall apply to them. So, although there's a general presumption in international law, there's a specific provision in the Treaty on the Functioning of the European Union which says there shall be an application to the Channel Islands by reason of it being a European territory. And that's what the Grand Chamber has told us in the Jersey produce case. So,
I hesitate to interrupt, but from paragraph 6 through to 8, the position is explained in the Advocate General's opinion.
yes, and it's then picked up by and repeated in the Jersey produce case. But two other points have to be made in relation to the Jersey produce decision. First of all, it, like the Rock decision, are Article 267 references from courts in Jersey. And we know that Article 267 can only be prayed in aid by, in cases pending before a court or tribunal of a member state. So so clearly the Jersey courts and the Isle of Man courts are treated as courts of the member state for these purposes. So again,
well, they are
just
for
shows
some purposes, but not for others. But where I thought you were going with this is to say that the exclusion of Jersey from the VAT exception, the VAT territory, you say does not affect the scope of its rights to enforce the general principles of EU law. Whereas what the Treasury say and what the courts below have held is that insofar as those general principles are sought to be applied in respect of matters where Jersey is clearly outside the EU, the general law that applies to the rest of the EU, it can't rely on them. Is that where we're getting to ultimately?
And I see they can rely on them because they are, just as the Åland Islands, as the presumption of the Council was that they applies to the Åland Islands because they're within the territory of the Customs Union and therefore covered by the free movement of goods. So, yes, but all I'm at the moment is still trying to deal with is the Schrödinger cat defence.
Yes, but I don't see what help we get from seeing that they are included in Article 267 or they're not included. What we have to focus on is what is the effect of their exclusion from the VAT directive on their ability to enforce general principles of EU law across the board.
Well, I suppose the clue's in the name general principles. It's a general principle which applies to, in the context of free movement of goods, all territories without reference to origin within the Customs Union. Now, one applies those general principles to them. There is no case that I have been able to find, and certainly none which HMT have identified, which says that general principles are disapplied. For example, the UK would not be able to rely on general principles in relation to any challenges it might make to decisions made under the Eurozone, or under the Schengen area, or under the area of common freedom, security and justice. Because the general principle applies not because of the VAT area, but because you're in the free movement of goods area. Now, the question of how it applies is a different matter, because we know that the general principle of equal treatment means that like categories have to be treated alike and different categories differently. Well, that is the requirement. And we know in this case that the like category of territories which are within the customs union and therefore can pay and aid equal treatment, but the Channel Islands is outside the VAT area while within the customs union. So therefore it can claim equal treatment as regards the treatment of other territories similarly outside the VAT area but within the customs area, i.e. the Åland Islands, the Canary Islands and the like. And that equal treatment has not been afforded in this case. That's the point which is being made. And it cannot be said, and the point which I'm trying to counter, I think is a very bad one, but it's one which is repeated throughout HMT's case, is that the Channel Islands are somehow not a member state, and that one can compartmentalise or silo the aspects when it is a member state, or it's not within the European Union, and is to be treated as if it were a non-member state, and other times it's to be treated as if it were within the European Union. That's not how it works. So, and the other point to be made is that you know that, because the Jersey Produce Grand Chamber case tells us, is that the council a council regulation was made concerning the arrangements applicable to Channel Islands and the Isle of Man, as envisaged at the end of Article 1 of the Protocol 3. That's Regulation 706/73. Well, council regulations can only be made, and they're only directly applicable in member states. That's what Article 288 tells us, and that's at the supplementary bundle, pages 22 to 23. That says, to exercise the Union's competence, the institution shall adopt regulation directives. The regulation shall have general application, it shall be binding its entirety, and directly applicable in all member states. So, going on then, there's the very position taken by HMT in their case. They say that Article 110 is what applies in this case, not Article 130. But Article 110, and they say that at their case at paragraph 36, page 141, you see this: the legality of import VAT under EU law falls to be determined under Article 110 because it is part of the common system of VAT laid down in harmonising directives. So, they're saying that if Article 30 doesn't apply, as they say it is, then...
I'm sorry, Mr. O'Neill, you've just given a reference and I'm frankly lost. You were referring us to page 141, did you say?
Yeah, this is paragraph 36 of the case.
So 141 of which bundle?
Main.
Main bundle.
Yeah, main bundle. Sorry.
Thank you. Right, thank you very much.
That's where HMT take a positive position that this matter has to be determined under reference to Article 110 because it's part of the common system of VAT. Yeah. But the point which we make is that Article 30 and Article 10 only have applications to territories that lie within the customs union and within the internal market for goods. Article 30 says customs duties and charges having equivalent effect shall be prohibited between member states. It applies also to customs duties of fiscal nature. Article 110 says no member state shall impose on the products of other member states any internal taxation of any kind, and no member state shall impose on the products of other member states any internal taxation of such a nature as to afford indirect protection. So both Article 30 and Article 110 apply to trade within the internal market and not to trade outside the EU. They are treaty provisions concerning the free movement of goods within the internal market. So that means, in putting a positive case that Article 110 applies, the HMT are required to accept that JCL is trading within the area of the internal market and not as if it were a territory outside the EU, and therefore can claim the protection of the free movement of goods.
But there are lots of third countries, entirely different countries outside, which are quite clearly not member states, which have a trade arrangement which treats them as if they were within the customs union. But do they also then acquire the rights that you say JCL has?
They would. That depends on the terms of the. And there aren't that many countries. I think Turkey is the only one that immediately comes to mind. It depends on the terms of the association agreement. And in the case of the Turkey. In the case of the Turkish case, we do have association agreement. We do have the case of Istanbul Logistic, in which the general principles of free movement were heard to be able to apply in that case. But you know, we're not in this case dealing with an association agreement of any sort, because that's an external matter. We're dealing here with a protocol which is an integral part of the EU treaties. So, all one can say is that when one looks at it, the Channel Islands was and always was and remained a territory within the EU. The fact that some provisions of EU law were disapplied or didn't apply in full to the Channel Islands didn't place the Channel Islands outside the EU. All it did was simply an example of what's called variable geometry of EU law. But otherwise, given that it falls within the customs territory and the internal market, GCL remains entitled, to, as a matter of EU law, to preannate general principles of EU law, and more particularly, to maintain its claim to equal treatment compared to other producers operating elsewhere in the territory of the internal market, which are also outside the VAT area. So the claim that for VAT purposes, and if you remember, VAT is also just an internal market provision, that the Channel Islands become a third territory wholly outside the EU is wholly untenable. It's just not available as a matter of how the treaties work. And given that, then we can claim the protection of the general principles of equal treatment, which we rely on precisely because we are within the internal market and the customs union. Now, this second line of defence, second main line of defence I take from the case is that, okay, see, HMT, if the Channel Islands, even if they are within the EU, when it comes to VAT, we are authorised by EU law not to apply, effectively, for the principle of equal treatment to be disapplied. And they say that that's what the Gaston Schul case says. But again, and I'll come on and look at Gaston Schul, but before I do so, a VAT case says in terms that the general principle of equal treatment across the internal market does apply. We see that in NCC construction. It's at tab 74, page 1589 in the main bundle. At page 1610, paragraphs 41, referring to the principle of fiscal neutrality, which is applied in VAT law. The principle of fiscal neutrality was intended by the community legislature to reflect in matters relating to VAT the general principle of equal treatment. Going on to paragraph 44, it is also appropriate to point out that the general principle of equal treatment, of which the principle of fiscal neutrality is a particular expression at the level of secondary community law and in the specific area of taxation, requires similar situations not to be treated differently unless differentiation is objectively justified. It requires in particular that different types of economic operators in comparable situations be treated in the same way in order to, this is the important point, in order to, within the context of a VAT case, in order to avoid any distortion of competition within the internal market in accordance with the provisions of Article 31G EC. That's now Protocol 27 of TFEU. And then it goes on at 45. In implementing the provisions of the 6th VAT Directive, the Member States were obliged to take into account the principle of equal treatment. The principle of equal treatment, as we've said, that is intended to avoid distortion of competition within the internal market, of which Channel Islands are a part.
Well, the whole point about the Channel Islands is that they have unequal treatment because VAT isn't charged.
Yes, And I've said...
And you can't rely on the principle of equal treatment to...
Yes, I'm sorry, my Lord, there is an application of the principle of equal treatment says that like cases have to be treated alike and unlike cases have to be treated differently. Now, the issue is that when one looks
well, then they should be paying VAT on all imports.
I'm sorry, if I can answer the question which has been asked of me, I will do so. It's difficult when I'm doing this remotely, but I will attempt to do so.
Good.
The position, as I've already explained, is that the principle of equal treatment then applies, and you look at the VAT legislation, and you see two categories of territories to which can claim the principle of equal treatment in terms of the free movement of goods. One category is within the EU VAT territory. The other category of territories is outside the VAT territory, but within the customs union, and therefore can claim equal treatment with those other territories in the same category, i.e. the Åland Islands and the Canary Islands and the other territories listed in Article 6.1. So if you're going to disapply VAT in relation or apply VAT on low goods from the Channel Islands, you have to, in accordance with the principle of equal treatment, do the same for the Åland Islands and the Canary Islands. And that was what was not done in this case. So the principle of equal treatment, and the result was it introduces more distortion, exports distortion into the internal market, contrary to the provisions of the treaty, which VAT is attempting to achieve of an internal market without borders. And it says, and going on at Article 40, paragraph 45 in the case NCC, in implementing the provisions of the 6th Directive, the Member States were obliged to take into account the principle of equal treatment, like the other general principles of community law, which, having constitutional status, bind those Member States when they take action in the field of community law. So, the UK was taking action in the field of community in this case. It says so itself. It was acting under in terms of Article 23 VED. It therefore was required to take into account the principle of equal treatment in order to avoid any distortion of competition within the internal market, as much of which the Channel Islands is a part. That doesn't mean to say that, therefore, the Channel Islands had to be treated in the same way as a different category within that internal market, but it does mean it has to be treated in the same way for VAT purposes as other territories within the same category, i.e. outside the VAT area, but within the internal market. Now, that's the case. That's what's said against them, and what HMT then says, oh, well, that's not really on point because... You see this at page 152 of the case at paragraph 65. The case concerned economic operations within the internal market as defined in the principle of that directive. That's not the case. I'm sorry, that is not what that says.
I'm sorry, you've gone to paragraph
65 of the case of HMT at page 152.
Where are we? Page? I'm sorry, I haven't got the reference either. Sorry.
152.
On
double check.
which bundle?
Main bundle, tab 5.
in bundle.
Thank you.
It's got a different...
Oh, I see. The written.
Paragraph 65, page 152.
Oh, I see. So this is the Treasury's written.
The case. This is the Treasury case.
Yes, I see.
So what they're saying is NCC was an internal Danish thing. It wasn't involving anybody with any peculiar status.
No. Well, what it says is that case concerned economic areas within the internal market as defined in the PVD, the Principal VAT Directive. That is not what the case says. It says that there is no definition of the internal market within the Principal VAT Directive. There's a definition of the EU VAT area, and insofar as there is a definition of the internal market, it's the customs union. So that includes Article 5 territories and Article 6.1 territories. So it does include the Channel Islands.
But that case was concerned with operators not only within the customs union, but also within the VAT area.
Yeah, but the dictates from the court are of general application, and they refer to not the EU VAT area, which they could have done, ensuring distortion of competition within the EU VAT area, but rather they refer to the treaty provision, not secondary EU.
Yes, but do you accept that the difference that there is a difference, whether it's relevant or not, is for us to decide, is between NCC and this case, because the court in NCC was not making those comments in the context of economic operators who were within the customs union but outside the VAT area.
The comments were made of general application, as the Court of Justice generally does. It doesn't have strictly a distinction under EU law between obiter and the ratio, but they are authoritative comments from the leading court, which tells us that when it comes to VAT, the provisions of equal treatment apply, which are intended to avoid distortion of competition within the internal market. And that is as defined in the treaty, and that is wholly consistent with the approach which we've seen was taken in the Danish case, which did involve the Åland Islands trying to get around VAT, and that, in fact, the solution which was allowed was one which applied across the internal market without regard to origin. So it's entirely consistent with it. The HMT claim is not consistent with it. It says that the internal, it seems to be suggesting that when you're in the VAT area, the equal treatment doesn't apply. That is not what this case says. It says if you're in the internal market, then, or even for VAT purposes, the equal treatment principle applies, which, as I say, doesn't mean to say that you have to treat them in the same way, but that any differences which are made have to be justified consistently with the principle of equal treatment, and in principle, territories within the same categories have to be treated in the same way.
Mr. O'Neill, coming close to the end of your allotted time now.
Well, indeed, the allotted time was 150 minutes in total, and so I'm hoping to, insofar as my time for the principal submission goes over 2 hours, then I'll take that away. I was hoping from any reply, because there are still points which I'd like to raise, and at some levels this is taking longer than I would expect. So, as it were, stealing time from any possible reply. That's what I would hope to do. Certainly, I'm not going to eat into any time which is allotted to 120 minutes, which has been allotted to the other side. So, that's what NCC says. But then you get this very, very odd claim in paragraph 65. Page 152 to 153, the Treasury say that when removing low-value consignment relief, the UK was not implementing or applying the directive in the Channel Islands. It was just applying it within the UK. But the whole point is it levied the charge on low-value goods that were coming from the Channel Islands. So it was exercising a power avowedly permitted under the directive in relation to low-value goods having their origin in the Channel Islands, and it was doing so within the ambit of EU law, and therefore it cannot escape, in this spurious manner, the requirement for compliance with the general principles of equal treatment, requiring the UK to treat different economic operators in comparable situations in the same way to avoid distortion of competition within the internal market. So, and we know in any event also that VAT has to be applied because Article 113, the legislative basis for VAT, says that VAT is a turnover tax which is harmonised so far as necessary to ensure the establishment and functioning of the internal market and to avoid distortion of competition, not to the functioning of the EU VAT area and to avoid distortion of competition within the EU VAT area. It doesn't say that. I take it there is no, I mean, it's got to be common ground, surely, that the Channel Islands fall within the internal market as defined in Article 26(2) of the treaty, and therefore can pay and aid the free movement of goods. That is clear from the Grand Chamber decision in Jersey Produce. So, but what faced with all this, what the Treasury then seemed to say is, yes, but it's VAT, and with one leap they were free, and they say that somehow the provisions of secondary law take primacy over the primary treaty provisions and primary general principles derived from this in relation to the free movement of goods. And they say that's what the case of Gaston Schul does for them. It's their get out of jail free card. And that's at tab 55, page 738.
Sorry, which 738?
No, 738.
It's 738.
Thank you.
Yes.
So they rely heavily on this case as saying that somehow VAT is the defence, and it means that it is never, and because this is VAT, it can never be subject to the provisions which are now Article 30 of the Treaty on the Functioning European Union, and it will never be a charge having equivalent effect. And so Article 30 can never be paid in aid because this is VAT. But that's not what the court ruled in Gaston Schul. What it said was that if insofar as a charge imposed on the import of a product into territory of a member state was imposed within the context of a general system of internal taxation which was applied systematically to categories of products in accordance with the same objective criteria and was applied irrespective of the origin of products, then it would fall for compatibility's sake within the terms of Article 110, because it would be internal taxation because it complied with all those requirements. But we know that there are further hurdles which a charge has to comply with in order to fall within Article 110 as opposed to Article 30. And we see, for example, in the Belgian Slovak case, which is at page 91, page 1999, at page 2006, paragraph.
I'm sorry, we're going to page 2006.
Yeah.
Yes, 2006.
And the case is at 1991. Thank you.
Yeah, 1999, 1999.
Thank you. Bear with me a moment. And which case is this?
This is a recent case which looks at the relationship. It's Fens Spall against Slovak Republic.
No,
And it's the most recent case which looks at the interrelationship between Article 30 and Article 110.
I'm sorry, I can't get this to work for a moment. No. Fens, thank you.
Paragraph 40. The court says, in order to relate to a general system of internal taxation within the meaning of Article 110, the tax charge in question must impose the same duty on both domestic and identical exported goods at the same marketing stage, and the chargeable event triggering duty must also be identical. So this is again a strong application of the principle of equal treatment. And only then will the charge be considered to fall within Article 110 and examined as to whether or not it was indirectly discriminatory or protective in nature.
Well, that's true in this case, isn't it? The same duties imposed on domestic goods and goods imported from the Channel Islands, identical.
No, I'm coming on to that. It's not. It doesn't. Because, one, it's imported by reference to origin in the Channel Islands as opposed to origin from other territories in the EU internal market. And its imposition in terms of horticultural goods in this case is not done in the same way, because domestically produced horticultural goods are not subject to VAT but are able to claim something called the agricultural VAT exemption. So on all those counts, it doesn't comply with the requirements set out. But they say that it's VAT, and Gaston Schul says that VAT is all right, and should not be examined in accordance with these.
That agricultural VAT exemption, is that farmers one that's referred to in a footnote in HMT's case? Is that what you're talking about?
It's referred to in the Statement of Facts and Issues.
Well, what's your competitive advantage then if there's no VAT on internal seed supplies? What's the competitive advantage, I thought you said?
It's competitive distortion because it's not being done as, in order to relate to a general system of internal taxation, it's got to be the same duty on both domestic goods at the same marking stage, and the chargeable event triggering the duty must be identical. These are the requirements in order to fall within 110, which is what HMT, the Treasury, say it does. And I say, well, it doesn't if you actually...
are you saying, I just want to be clear, because it's quite important, are you saying that if I order some seeds from somebody in the UK, low value, there'll be no VAT payable on them?
As I understand it, that's what Treasury say, that the agricultural flat rate scheme they can apply is exempts from the VAT issues. That's what they say in their footnotes in their case. In any event, whatever it is, it's a
different... That seems quite important, because I thought your whole complaint was that you had a special opportunity to sell them VAT free from Jersey, which they wouldn't have got by ordering them in England, and that's been taken away.
Yes, it has. But then they say in defence, but it's internal taxation. And my response to that, it's not internal taxation covered by Article 110, because that imposes further requirements in terms of the identity of the approach to be taken, and we say they haven't done that. So we say our first case is at Article 30 and equal treatment, and they say, and in response to their claim, it's Article 110, we see equal treatment still applies, and the equal treatment hasn't been applied in this case. But anyway, sticking with Gaston Schul.
We're back to Schul now, and 738?
Yes. So that's the 738. But Gaston Schul is expressly premised on the fact, as the court records at paragraphs 15 and 16 of its judgment, and that's at page 756, that all imports are subject to value-added tax in the importing country. It then goes on, the preliminary questions must be considered on the basis of those aspects of the common system.
So you're reading,
but of course, in this case...
Mr. O'Neill, where are we? Where are you reading?
Page 756.
Yes, paragraph
15, is that right?
Yes. So, this tax doesn't apply to all imports. It just applies to imports coming from the Channel Islands.
What point? Forgive me. What proposition do you get from paragraph 15?
That the case is being answered by the court on the basis that there is a uniform approach to the taxation of imports by subjecting all imports to value-added tax in the importing country. As it stood at the time under VAT law, one could tax goods that came in from other member states. And all is important because it's coming back to the principle of equal treatment. It is which requires equal treatment without regard to origin. This does have a regard to origin because it doesn't apply to all imports coming from elsewhere within the internal market territory, which is outside the EU VAT area, because it doesn't apply to imports from the Åland Islands. So Gaston Schul isn't supportive of the particular approach which has been taken in this case, even although they call it VAT. So, more going on at page paragraph 21 of the judgment, the court states that the relevant EU VAT directives have to be interpreted consistently with the free movement requirements of the treaty.
Sorry, where are you reading again?
21, did you say?
Paragraph 21.
Paragraph 21
Yes.
of Gaston Schul.
Yes.
Sorry, let's just see where you are.
It's page 757.
So you just tell us which bit you want to look at.
Paragraph 21 says this. It's apart from the considerations referred to above that this is not an import duty for the purposes of what's now Article 30. The tax is part of a system of value-added taxes structure which in essential terms have been laid down in the Council and harmonising directives. Those directives have established a uniform taxation covering systematically and according to objective criteria both transactions carried out as territory of member states and import transactions. And it makes imports and supplies of light goods subject to the same rate of tax. And it's because of that it is an integral part of the general system for the purposes of what's now Article 110. Now the point is that it doesn't say the common system makes some imports and the supplies of light goods within the territory subject to the same rate of tax as domestic goods. It is all imports, as I've said at paragraph 15. That's why it's a uniform taxation procedure applied systematically and for objective criteria. So, and it goes on then at paragraph 29. Page 760. At the last sentence of paragraph 29, since the tax is reflected in the market price of second-hand goods, the effective value-added charge is merely to compensate for the residue of tax, and thus to establish, from the point of view of perfect neutrality with regard to intra-community of trade, equality of treatment between domestic and foreign products. So once again, equality of treatment, not between domestic and some foreign products, because that wouldn't be perfect neutrality with regard to intra-community trade. So the VAT system, as properly applied, is one which applies and furthers, as you'd expect from Article 113, the perfect neutrality and the internal market without borders, throughout the customs territory of the Union. That's what it's intended to do. As it says then at paragraph 32, paragraph 33 rather, at page 760, the interpretation which it gives to Article 98.5, now 110, accords with the need to take account of the objectives of the treaty, which are laid down in Articles 2 and 3, and which appears to be the establishment of the common market. The concept of a common market is defined by the Court in a consistent line of decisions involving the elimination of all obstacles to intra-community trade in order to merge the national markets into a single market, bringing about conditions as close as possible to those of a genuine internal market, that not only commerce can benefit from that, but private parties. So, yet again, that, as properly understood, is one which applies and is subject to the principle of equal treatment to ensure the internal market works across the whole area of that common market. So therefore, even if it is VAT, as we've seen with the NCC case, it is still a question of having to be applied consistently with equal treatment and without regard to the origin of the product elsewhere within the internal market, which is what HMT have done in this case. The Treasury have applied the charge to and only to low-value goods coming from the Channel Islands. It's singled out those goods coming from that territory. That is the antithesis of establishing a position of perfect neutrality with regard to inter-community trade, which is what the VAT system, properly so called, is attempting to achieve. So, again, Gaston Schul, therefore, does not save the Treasury's case, because the charge in this case was levied under reference to a general system of internal dues. It wasn't levied systematically. It wasn't levied under reference to categories of products, for example, magazines or periodicals. It wasn't levied in accordance with objective criteria, because there was no case made out that there was any competitive distortions caused by low-value horticultural goods, and it was levied having regard to the origin of the product in the Channel Islands. And the fact that the Treasury say, oh, but it looks like VAT and we classify it as VAT, is not enough. It's a question of how it applies in practice. And that is clear from the decision in the Chamber of Commerce of Ceuta in the Spanish territory enclave in North Africa, the tab 73, page 1067. And that notes at page 1077.
Sorry, 1077. It's the
paragraph
Ceuta case.
10. Just give us the page number again.
1077.
1000.
Sorry?
I'm lost.
Yeah. Could we have the page again, please?
1077.
Yes, I'm sorry. Just double checking.
Yes. The Ceuta case.
Yeah,
The Ceuta case, yes.
Paragraph?
It's 1077.
Right.
Paragraph?
Oh, sorry, it's one. It's paragraph 29, it's 1076, apologies.
29, paragraph 29.
Yep, and it
Thank
says, since the aim of what is in Article 110 is to ensure free competition of goods, normal conditions of competition by the elimination of all forms of protection, which may result in the application of internal taxation that discriminates against products from other member states, the article must guarantee complete neutrality as regards competition between domestic products and imported products. And the prohibition which it lays down applies wherever a fiscal levy is likely to discourage imports of goods originating in other member states to the benefit of national production. It goes on then to examine precisely what that taxation system was applied in the Ceuta case. But at paragraphs 35 and 36, importantly, the court says, after examining the legislation, says it's possible that the application of the legislation by the competent national authorities doesn't meet the requirements of being subjected on the basis of objective criteria unrelated to origin to one and the same charge. That could be the case if the administrative authorities were to make systematic use for the benefit of local production of a power to grant exemptions. In this case, of course, we've got the agricultural flat rate tax, flat rate exemption. It is therefore for the National Court to consider whether the charge, although having the appearance of internal taxation, in fact constitutes a charge equivalent to a customs duty so far as imported products are concerned. So this is a clear situation of, even if it looks like, even if, as the test, the only test which applies, or it looks like that, although it doesn't, because it is in fact applied selectively with regard to origin, if it's applied in a way which in fact makes systematic use for the benefit of local production of a power to grant exemptions, it will then, despite its classification, then become a charge under Article 30 and prohibited by Article 30. That's the case which should be made against them. The Treasury seem to find it extraordinary, but that's what the case law says. So, as I say, the charge which has been imposed in this case impedes the free movement of goods. So it's therefore not in accordance with Article 110, Article 30, or even the VAT system. because it impedes the free movement of goods, it distorts the conditions of competition across the internal market by giving competitive advantages to other businesses elsewhere in the internal market. It doesn't apply systematically to categories of products. It's not levied irrespective of origin of products. It has no objective justification. It's not the same charge which is applied to domestic goods, because domestic farmers had the option of applying for the agricultural flat rate scheme. And it's not imposed at the same marketing stage anyway, because it's just imposed on import. So, in sum, because I do see that my time is running out, the third round of appeal is to the effect, and I'm putting it would be incompatible with UCL's fundamental rights for this case to be struck out at this pre-trial interlocutory stage, because it would be deprived of the opportunity of establishing the facts at issue and an examination of the claim and the merits. It's a claim of undoubted legal and factual complexity. The resolution of the classification of the charges, clearly from the case law, requires an acutely fact-sensitive analysis. It's a very delicate operation because, as has been noted, Article 110, Article 30 and Article 113 all have the identical purpose and are complementary in nature, which is to ensure the free movement of goods throughout the internal market and the non-distortion of competition. And the simple categorization by a member state of taxation doesn't take it out of the ambit of Article 30, because as we know, Article 30 in terms applies to fiscal measures. So, it is clear in this case that the problem that HMT have fallen into is that they seem to think that one can make this classification a priori without regard to how the facts are applied. That is not the case. It's not an a priori decision. It's not what is obvious. The issue is, how is this tax being applied in practice? The other besetting error is that Article 30 on customs or fiscal charges having equivalent effect to customs duty, Article 110 on non-discriminatory taxation, and EU secondary law passed under Article 113 are not discrete compartmentalised areas of law encased in silos unconnected to each other. They are instead all specific treaty expressions of the ways in which the EU seeks to achieve a unified internal market without borders, where goods can move freely and under normal conditions of competition. And the fundamental means to that is treating goods equally. That's the fundamental basis underpinning the free movement of goods and non-distortion of competition. So all of that points to the fact that you cannot compartmentalise a priori, but in fact the classification happens at the end of the process of examining the facts that makes this case ultimately and completely unsuited to being struck out at this stage before the facts have been established, before indeed HMT have been called upon to actually set out on the facts of their case, which they've been required to do, that the charge which they are putting forward in this case falls within the definitions of Article 110 in ensuring the free movement of goods in normal conditions of competition and is being applied systematically to categories of products irrespective of origin on the basis of objective criteria, and is being applied by the UK authorities in accordance with all those criteria. It hasn't done that. That's because it's not been called upon to do so, because the case hasn't gone to trial. That is the case which is made against them. That's the case they're called upon to answer. That is the case which the appellant should be permitted to proceed with. And on that basis, I ask the court to uphold the appeal. So, unless there are any other matters arising, those will be my opening submissions. And on my count, at least I've got 10 minutes left.
Can I just raise a point? If you go to page 146 of the bundle.
Yes.
Footnote 19.
Sorry, page?
146.
This is
the respondent's case.
Yes. there's a reference at footnote 19 to the flat rate scheme for farmers.
Yes.
Special exemption for farmers. Yep. Right. And now, yes. Is that what you're referring to when you talk about the domestic situation? As I understand, yes, that is what you're referring to.
That's what we're referring to, and it's mentioned also in the Statement of Facts and Issues at paragraph 9, page 61.
When I go next spring to my local garden centre and buy my bedding plants, yes. I think will be paying VAT on those plants, or am I wrong about that?
Well, all one can say is that you may be paying it, but the farmers who are supplying it aren't paying it.
Right, but the garden centre will have added VAT onto the price of the bedding plants or whatever that it sells.
The discrimination is not between the garden centre.
Can you just answer whether my understanding is right or wrong?
Well, I'm sorry, that is not my area, but what I can say is the EU law says that the discrimination, which is relevant for these purposes, is between domestic producers of the same goods, and the producers are the farmers and the producers in the Channel Islands who are not eligible to fall into the scheme which is provided for domestic farmers producing the same products. So all I'm saying on that basis, it doesn't fall within the definitional requirements of Article 110 and Article 113.
Sorry, can I just ask something following up from that? On page 118, it's your case. Footnote 15.
Yes, the primary comparator when it comes to Article 30 is between domestic VAT traders and is between import tax and Channel Island traders and other producers elsewhere. That's to get the complete neutrality of the market. And the point about comparing to domestic producers is even if you do compare to domestic producers, as the Treasury say you do, under Article 110, we see that there isn't equal treatment there either. So that's the only point that's made. Our primary case is in terms of Article 30, which would involve looking at how the internal market as a whole is looked, has an impact upon. But I'm taking the Treasury case at its best, and even at its best, it doesn't allow for the necessary equal treatment between domestic producers.
Thank you. Anything further? Thank you very much. Thank you, Mr. O'Neill. Ms. Seymour, we'll rise now. We'll sit again at 2 o'clock.